thank you for your patience. We're just getting a few things in order, including me. So obviously tonight is a demonstration of Moots, and I just want to start by asking, who has basically no idea what a Moot is? Okay, few of you, that's fine. And who hasn't mooted before but thinks they do have a pretty decent idea? Great, and who's actually done Moot before? So I am James Fraser. I was a GDL student at City last year, and I suppose I was probably in the same position as kind of the second lot of you there, in that I felt like I knew what a Moot was roughly, but I hadn't done one. By the end of the year, I kind of learnt enough. I've been lucky enough to win a couple of Moots. I don't say that to show off to you. I say that to hopefully add some credibility to the fact that I'm sat here and judging this thing. And I hopefully I can kind of impart some valuable things that I've learned along the way. So the structure of what we're going to do here is I'm going to speak for about 5 minutes on just introducing a little bit about how Moots work. Then we're going to do our Moots, and we've got 4 volunteers who very generously given up their time and, in my experience, a lot of stress in order to do this. So please do be very, very supportive of them, because what they're doing is not easy. And then at the end, I will give some feedback for them. I won't be deciding who's the winner because it's not a competition. Hopefully, it's takes a little bit of stress off you 4. So would anyone like to venture an answer to what a Moot is? Perhaps some of you veterans in the crowd. Go on.
Is it like a kind of role play of a court kind of situation?
Oh, what's that?
Like a role play of a court?
Yeah, good. So it's essentially a mock hearing. And it's typically an appeal hearing. Does anyone know why it's typically an appeal hearing? More a technical question. Yeah.
So some points of law rather than fact.
Exactly. So if it were a first instance hearing, there might be evidence, witnesses, cross-examination, so forth, and that's not really the name of the game here. It's just about arguing points of law. As you know, when we get to the kind of appellate jurisdiction, so not really arguing in facts, it's just the law. And how else is it potentially different from an actual hearing or trial? Anyone want to offer an answer to that? Yeah.
They argue upwards and loads of facts.
Okay, but even compared to a real appeal hearing, where they would still just be arguing on points of law. Okay, well, I'm going to suggest that one way it's different is that the outcome obviously doesn't matter. And related to that, I'm not going to be judging, or the point of the Moot is not really who has the better case. It's about who argues the case better. So an ideal Moot problem will, of course, be quite balanced. So there'll be good points that can be made for both sides. That isn't always the case, unfortunately. And actually, generally, one of the sides is probably stronger than the other. So probably 2 of the 4 people sat in front of me here are feeling slightly more confident than the others. But ultimately, my task as the Moot judge in theory is not really to decide the case in that way. So I'm looking for the quality of the advocacy of the legal presentation. So perhaps my final question, what do you think is important, or what do you think are the sort of marking criteria for? I mean, there's quite a few. Anyone want to throw something out there? Yeah.
Clarity.
Yeah, definitely. Don't be shy.
Advocacy.
Yeah, advocacy in general. I suppose there's a few things you might think of within that. Okay. Feeling shy tonight. I'd probably say things like pace, tone, register. So are they addressing the judge in the appropriate language? Are they speaking sufficiently formally? I think probably an underrated marking criterion, in my experience, is actually legal analysis. Because the better you analyse the case, probably the easier it makes it for you to deliver high quality submissions that would be ripped apart by the judge, not that I'm looking to rip anyone apart tonight. Also time management. So tonight, each of our mooters will have 10 minutes to speak, and obviously it's about, can they deliver that argument or whatever they want to get across in that time. Luckily, we've got someone who will hopefully be speaking with advice. And so we've got an appeal, so we've got appellants on this side, respondents over here, and it's a pretty standard format tonight. So we've got two grounds of appeal. We're going to hear from the senior appellant putting forward the case, and then the senior respondent who will be arguing back on that particular ground of appeal. And then, if you like, we've got a completely separate issue where we have our junior appellant and junior respondent. And of course, the classic thing which everyone gets a bit excited about with Moot is judicial interventions. So I will be, as any judge does, asking some questions, unhelpfully interrupting our meeting as we go along, mainly to show what that looks like. And obviously that's an important part of how a Moot would ordinarily be marked, is the judge would be thinking, well, how well did my questions get dealt with? Okay, is everyone, have people been sent the problem that we're dealing with here? No, okay. Well, I think it might be helpful if I very briefly, I won't read out exactly what notice has been given. But essentially, we had an advertisement in the local newspaper by a butcher who is our respondent in this case. And the advertisement said the following: special opening offer, shoulder of sheep, £1 per kilo, minimum order 100 kilos, maximum order 1,000 kilos. This special price lasts until the 31st of August. Customers wishing to take advantage of this offer must notify us 24 hours in advance of collection. So our appellant sent an email to the butcher at 10 AM on one day, saying that he wanted to order 1,000 kilos for collection the next day at 2 in the afternoon. But 4 hours after he sent the email, the respondent published a new advertisement or a notice in the paper saying that each customer was actually limited to only 100 kilograms rather than 1,000, which the appellant had asked for. Only 4 hours after that did the respondent actually read the original email. So our purchaser of the meat from the butcher is quite upset because they haven't been provided with 900 kilograms of what they thought they were owed. And so they're claiming for damages for breach of contract. So you probably know a little bit about contracts. You've got to have an offer, you've got to have acceptance. And first ground of appeal here is that there's no rule that an advertisement can't constitute an offer. So the respondent is saying that the advertisement wasn't an offer, and it couldn't possibly have just been taken up by our appellant just like that, or the appellant disputing that. The second ground of appeal is that email should be governed by the postal rule, which you may have heard of, which would be, if it applied to an email, telling us that actually the moment that the email was sent, the contract was formed between the parties. So that's probably all I need to say at this point. I'll stop ranting on. And yes, as I say, it's scary, be supportive, and let's see how we get on. Bills?
Good evening, my lord. Tonight, council shall be presenting submissions on behalf of the appellant, Mr. Christophe, alongside my learned junior, Miss Yusuf. My learned opposition shall be presenting submissions on behalf of the respondent, Mr. Allen. Would my lordship care for a brief summary of the facts of the case?
Yes, why don't you go for it?
There was a newspaper advertisement published on behalf of Mr. Ali stating that he was offering 100 kilograms and 1,000 kilograms as a lower threshold at £1 per kilogram in a local newspaper. This was a short-term ad, as the offer was for the opening of such a butcher shop. Following on from this, an order was placed. However, it was not completed by Mr. Ali. As a result of this, the appellant suffered damages in the four-figure range.
Very good.
Do I have my Lord's permission to dispense with formal citation?
Absolutely, please.
I may direct my Lord's attention to page 4 of the senior appellant's bundle, where you'll find one's skeleton argument, and view the paragraph under the subheading Grounds of Appeal.
Yes.
Council requests the court accept both grounds of appeal submitted by Mr. Christopher. First ground of appeal being that there is no rule that an advertisement cannot constitute an offer, and the wording of the advertisement did indeed constitute an offer rather than an invitation to treat. The second ground of appeal being that the email sent by the appellant should be governed by the postal rule, and Mr. Ali clearly implied that an order placed by letter or email would suffice. Council shall be presenting two submissions in regards to the first ground of appeal. The first in regard to the distinction between offers and invitations to treat in advertisements, and the second in regard to the wording of said advertisement. With my Lord's permission, I shall present my first submission.
Please.
Council submits to the court that in general application, there may be a rule against advertisements constituting an offer as established by Partridge and Crittenden. My Lord, please turn to page 9 and read the highlighted passage in paragraph 8.
This is the one that begins when one is dealing with advertisements and circulars.
Let us pray.
Yes, go on.
Case before the court today, council is in agreement that under the general rule, there be no offer, but there is an exception to such a rule. Such an exception was established in the case of Carlisle and Carbolic Smoke Ball Co. My Lord, will please now turn to page 18 and read the highlighted passage, which continues on to the first paragraph, page 19.
Yes, that's quite long, Mr. Hills. Could you give me perhaps the thrust of what that passage is? What would you want me to get out of that?
The key message from such an extract is that the exception applies when the advertisement is in regards to a unilateral offer and can be accepted via performance rather than formal written notice by the recipient, and that no further negotiation or bargaining was intended by the publisher of such an advertisement. Mr. Ali's advertisement clearly states in clear and unequivocal language that one shoulder of sheep shall be £1, minimum order 100 kilos, maximum order 1,000 kilos. As a result of this, he also states the time period in which such an order shall be facilitated. This advertisement clearly demonstrates that the purchaser, in this case Mr. Christopher, only needs to contact them and tell them the desired quantity and as and when they require such meat. They shall form the contract as they have fulfilled the necessary performance as established by the advertisement. On this basis, council submits that this advertisement does indeed constitute an offer based on the common law precedent, as the advertisement presents a unilateral offer in unequivocal language. Does anyone have any questions regarding the first submission?
Yeah, I just have one question. So you tell me that a unilateral offer is, or a unilateral contract is where you have performance of something, performance of an action by the one party, and then. So what do you say was the performance in this case?
Council submits that the performance in this case was the response to Mr. Ali, indicating the quantity and the time in which they would receive it.
But isn't that much more like just your standard bilateral contract? It seems to me like Mr. Ali has put out this advertisement. Mr. Christopher said, I accept, and tomorrow I'll pay for it. That's when I'll do my performance. So I'm slightly struggling to see how the unilateral contract analysis applies. Could you maybe persuade me that that's this really is performance and it wasn't just the next day that performance was happening?
There was no negotiation taking place between the parties. There was a set price, and as a result of this, there was no written contract. And furthermore, the submission of his assent to the terms, him in this case being Mr. Christophe, was the performance required, as there was nothing else besides this. And whilst this may occur to my lord as a bilateral contract, the fact that it was not pre-negotiated illustrates to council that it was indeed a unilateral contract.
Very good, thank you.
With my lord's permission, I shall present my second submission. Council submits that the wording of the unilateral contract between the parties did constitute an offer and not an invitation to treat. The case of Gibson and Manchester City Council established there can be no equivocal language used in the offer, and it must be capable of acceptance based upon the advertisement, otherwise there shall be an invitation to treat. My lord, please turn to page 35, paragraph 3 of the senior appellant's bundle.
Yes, I have that.
Lord Russell stated, I cannot bring myself to accept that a letter which says that the possible vendor may be prepared to sell a house to you can be regarded as an offer to sell capable of acceptance so as to constitute a contract. The advertisement published on behalf of Mr. Alley included unequivocal language such as the pricing and the time needed to prepare such an order. Such phrases leave no room for speculation as to what the terms of the agreement would be. On this basis, Council submits that the wording of the advertisement constituted an offer capable of acceptance due to this nature and not an invitation to treat.
Sorry, is it not a problem for you that there isn't really an actual amount specified? I mean, it says 100 kilos minimum, 1,000 kilos maximum. Maybe if it had said 500 kilos and then the appellant had said, yes, I'll take the 500, I can see that that would be a very clear, unequivocal, as you say, offer. But what do you say to the suggestion that this range indicates maybe a lack of acting?
Council acknowledges my lord's point. However, if there was such a set amount, it limits the capabilities of parties to contract fill other obligations, as with the facts of this case. At the time of contracting, it was unclear the quantity of meat that he would need to provide for such a festival. If council is recalling correctly, it was an Islamic festival, and as such, there was specific requirements for such an event. And if it was limited to certain terms and not allowing this range to contracting parties, it would have impeded their ability to fulfill their ulterior contractual obligations.
So you're saying it's sort of a matter of, in business sense, this is just the reality of how commercial parties work.
Quite.
Well, if that's the case, does it not seem a bit absurd to you that Mr. Christophe could bind Mr. Ali like this? I mean, what if there had been 20 Mr. Christophs and they'd all emailed Mr. Ali saying, I'll take 1,000 kilos? What if he didn't have all of those, that much meat going? That doesn't seem to be necessarily commercial good sense to me. What do you say to that?
Council submits that it cannot be on the behalf of the contractor and the acceptance of such an offer made up before. There cannot be an expectation that the party coming into the contract has superficial knowledge of the dealings of the other party and their commercial standing. For this is just simply unreasonable. To rebut the presumption that if not all terms have been finalised, the contract cannot be formed, the case of Storer and Manchester City Council established that even if not all terms are agreed, the contract may still take form and be binding. My lord, please turn to page 41 of the bundle and read the highlighted passage in paragraph 7. Does my lord have something?
I do, yes.
Lord Denning states that a man cannot get out of a contract by saying, I did not intend to contract. If his words were, he has done so. His intention is to be found in open expression only. It is on this basis that the terms set before us today amount to the intention of the contract of the parties to enter a contractual obligation with one another. Does my lord have any further questions in relation to either of council's submissions?
No, I don't. I think I've got the loud and clear. Thank you.
Like you no further assistance to the court, I shall pass over to my learned friend.
May it please the court, I appear as the senior counsel for the respondent, Tariq Ali. It will be submitted that this appeal should be dismissed on the grounds that there is a clear rule that an advertisement constitutes an invitation to treat as opposed to an offer, and the wording of this specific one by the respondent did not constitute an offer. If it pleases your lordship, may I proceed with my first submission?
Yes, and how many submissions are you making?
I am making 2 in total.
Could you perhaps just clarify for me what those 2 will be in advance?
So the first one is that there is a clear rule that an advertisement constitutes an invitation to treat as opposed to an offer, and that the wording of this specific one by the respondent did not constitute. If it pleases your lordship.
So that's your first submission. Well,
The first submission is about a clear legal precedent
right.
that sets advertisements out to usually be invitations to treat rather than offers. And the second one deals specifically with this one
I see.
by saying it doesn't fulfill the standard.
Thank you. Forgive me. Please.
If it pleases your lordship, may I proceed with my first submission? I'm grateful. To begin, it will be submitted that advertisements usually constitute invitations to treat rather than unequivocal offers, which disregards the respondent from the intention to be bound by the agreement. I would like to refer your lordship to the case of Granger and Son and William Lane Gow. Is your lordship familiar with the case?
I am, but perhaps you could just briefly summarize it for me.
So in Granger and Gow, Granger and Co., a wine merchant, sent a price list to Gow, which included the prices of wines with no specific terms attached. Gow, upon receiving the price list, placed an order for the wine based on those prices. Granger and Co. later refused to deliver the wine, arguing that the price list was merely an invitation to treat and not an offer capable of being accepted. In judgment, the court ruled in favor of Granger, and the case established that price lists, catalogs, or advertisements generally do not constitute offers but invitations to treat. That means that when a party places an order based on such materials, it is not automatically binding. Instead, the party making the offer can still refuse to complete the transaction. In the instant case, it is submitted that the price list in Granger and Gow is a similar mode of advertisement as the one that the respondent put out, wherein it was said that there could be a minimum order of 100 kilos or a maximum order of 1,000 kilos. This is not specific enough in its terms to be an offer, and rather it is about an offer for a variety of amounts of sheep shoulder. The decision in Granger and Gow is supported by the decision in Partridge and Crittenden.
Yes.
Would your lordship like a brief summary of the case?
No, I'm very familiar.
This is not in the bundle, but I would like to refer your lordship to what Lord Parker says in the case, where he says that in dealing with advertisements and circulars, there is business sense in their being construed as invitations to treat and not offers for sale, and that this is supported not just by the law, but common sense. In the instant case, it seems to apply that the court has consistently held that advertisements, unless they are clear, certain, and unequivocal, do not constitute an offer capable of acceptance, as advertisements by their nature often lack the specificity and intention to be immediately binding. Furthermore, I would like to refer your lordship back to the same case of Partridge and Crittenden, this time to what Judge Ashworth says, which is that in that case, the words offer for sale do not constitute an actual intention to offer. And as equally plain as it is as perhaps articles in a shop window, namely the insertion of an advertisement in this form is simply an invitation to treat. In the instant case, this is similar to the advertisement itself, where it is said that it is a special opening offer. This term is open to interpretation and does not unambiguously indicate an intention to be immediately bound by the terms of the offer.
So what do you say to Mr. Hill's point that it's not really fatal to this matter, that it could be anything between 100 to 1,000? Because you're telling me that that's evidence of a lack of specificity. He
Yes.
says that actually that's pretty good common sense, isn't it? That you would have everything specified, for example, like in a price list, like you mentioned from Granger. Or do you think that perhaps it really does have to be absolutely crystal clear to amount to an offer?
I do believe that it has to be crystal clear. And if I would invite your lordship to look at the entirety of the advertisement, there's also a term that also says that customers wishing to take advantage of this offer must notify us 24 hours in advance of collection. I feel that that's gives that even with say this threshold, the advertisement as a whole the advertisement as a whole still gives the respondent an adequate amount of control over the terms of the sale, because he is not guaranteeing that immediately if you ask for 1,000 kilos, then he will give 1,000 kilos. In the context of the advertisement, it seems that he has to look through his stock. He has to check if he can actually offer that.
Okay, yeah, thank you. Please continue.
Your lordship, may I move on to my second section?
Yes.
It is submitted that, as per the facts of the advertisement, for an intention to form, there's a presumption that further communication is required. I would like to refer your lordship to the case of Harvey and Facey. Is your lordship familiar with the case?
Yes.
So in Harvey and Facey, the case established the principle that a statement of price or providing information in response to an inquiry is generally still an invitation to treat and not an offer. To form a valid contract, the offer must still be clearer than that, so that the other party can accept.
Sorry, just before you continue, wasn't Harvey and Facey a case involving land? So I would have thought that that situation.
Sorry, Harvey and Facey was about the sale of pens.
Was it Harvey and Facey?
And Facey, Facey.
I believe it was a pen in the sense of a pen like a bumper hall pen.
Yes.
It may be that that's not a problem. I just would be grateful if you could address me on that point. Is it fatal to your argument that that was the case involving land?
I would not say so, because I think the crucial point of the case is the idea of an offer that presumes an inquiry of information from the other party. And in that sense, it is because there must be an inquiry for information from the other party to really actually get a contract going. That constitutes the advertisement as an invitation to treat rather than an offer, because there are no clear terms.
Understood. Thank you.
In the instant case, as I mentioned to your lordship before, there was the 24-hour notice requirement in the respondent's advertisement. And this serves as a crucial indicator that it was an invitation to treat rather than an offer. By stipulating this advance notification, he preserved the opportunity to review stock availability, verify terms, and maintain discretion over the final transaction. And it created a clear sequential process. First, a customer expresses interest. Second, they provide notice. And finally, the respondent himself decides whether to proceed with the sale. Such a structure aligns with established commercial practice, where merchants retain control over the contract formation rather than being automatically bound by customers' responses. The advertisement therefore demonstrates the essential characteristics of an invitation to treat. namely that it invites customers to make offers which the merchant may then accept or reject. Does your lordship have any questions as to my second submission?
Thank you.
If unless I can be of further assistance to the court, my submissions are complete.
May it please the court, I appear as the junior appellant on behalf of Mr. Jean-Christophe in his application for appeal. May counsel check that you have received my one-page skeleton and 125-page bundle, my lordship.
I have received all 125 pages of it.
I'm grateful. Counsel submissions rely on two grounds. First, an email should be governed by the postal rule and not the principle of telex. And second, an advertisement clearly implies that an order placed by letter or email would be considered as sufficient and binding. My lordship, as my learned friend has presented a brief summary of the facts of the case, may counsel move on to submissions?
Yes.
I'm grateful. Counsel's first submission addresses the acceptance of email as within the guidance of the postal rule. Acceptance via email has similarities with the postal rule, whereby it is effective upon sending within business hours. This is a relation from Thomas and BPE solicitors, and that emphasizes the link to the postal rule, where the court has accepted email as a similar form of communication to the postal rule because of the sending times. My lordship, will you benefit from a brief summary of the facts of the case, or may I continue submissions?
Of Thomas.
Yes.
Yes, if you wouldn't mind, just a brief one.
The claimant sued the defendant over the way they handled the sale of the claimant's shares in the company. The acceptance of email was agreed as effective when it was received during normal business hours. Does that satisfy your lordship? And can I continue? Yes.
That's all right. Yes, please continue.
I'm grateful. May your lordship turn to page 36 of the bundle. Oh, sorry, 37, my apologies.
Yes.
It states in the quote, in the context in which the 6 o'clock email was sent about the transaction which could have been completed that evening, I do not consider that 6 o'clock was outside working hours. The email was available to be read within working hours, despite the fact that Mr. Prusak had in fact gone home. This is referring to a description of the time the email was sent. And this supports the appellant, whereby the email was sent on the 24th of August, accepting the offer on advertisement as within standard business hours, which the appellant had sent at 10 a.m. This constitutes as a binding contract upon the appellant's acceptance. My learned friend may argue that email is more similar to telex, to the postal rule, but this is disputed because the case here shows that whilst email is considered an instantaneous form of communication, such as fax and telex, it can be considered by the courts in circumstances where there may be potential delays in reading emails outside of business hours.
Forgive me, I'm just a little bit worried about your reliance on this authority, just based on what I see a few lines up. So it says at the start of paragraph 90, once one sets aside the postal rule as inapplicable to email communications, is that not the context of the excerpt that you've taken to?
It is, and while counsel recognises that the judgment dismisses the postal rule, it does consider the time of the business hours, which is what counsel's argument was implying towards, rather than the postal rule directly.
Understood. Yeah, thank you.
The respondent had the opportunity to read the acceptance within the business hours, as it was sent at 10 a.m. early morning, which would be constituted as a business hour.
Yeah, I'm certainly with you on that.
This is therefore considered as of sound business practice, as said in Brinky Bond and Starhag und Star. My lordship, will you benefit from a brief summary of the facts of the case before counsel continues with submission?
Please.
The contract was made in two separate countries, England and Austria. It was disputed whether the contract was formed and whether a breach of contract would be considered an English law. And it was found that it was actually an Austrian case, so it would be sent for the Austrian courts.
Okay.
My lordship, may you turn to page 15. There are two quotes, pink and green, that will be considered.
Yes, I see that. Yes.
Where the condition of simultaneity is met, and where it is to be within the mutual intention of the parties that contractual exchanges should take place in this way, I think it's a sound rule, but not necessarily universal. The message may not reach or be intended to reach the designated recipient immediately. Messages may be sent out of office hours or at night with the intention or upon the assumption that they will be read at a later time. The quotes here consider the intention to create a legal contract on sound business, where both parties intended to create a legal contract via email, despite the time the email was sent. This can be applied to the parties here, where the advertisement was made an offer on sound business, and where the appellant has accepted this. Furthermore, we must consider relevant material to amount to acceptance, which is supported by Moot Lines Limited and High Seas Shipping Limited. This is on page 68 of the bundle. The quote here states that it is not to send, clicking on the send icon automatically that amounts to a good service. The email must, of course, be dispatched to what is in fact the email address of the intended party. It must not be rejected by the system. If the sender does not require a confirmation of receipt, he may not be able to show the recipient has occurred, the receipt has occurred. The quote here shows that an email may be considered as effective service as the appellant and respondent would both have the receipt of the email acceptance sent. This is applied the same as the postal rule as receipt is obtained upon sending. Thereby, by establishing a relationship to the postal rule from email, counsel invites the court to allow the appeal on the second ground. If your lordship has no further questions, counsel would like to move on to the second and final submissions.
I'm just struggling a little bit with your argument. So suppose that your client sent an email to the respondent.
Yes.
And then immediately got a message back from the email server saying message not delivered.
Yes.
Would he be bound? Would that have formed a contract?
No, because the receipt is not obtained, as there's a response back saying that the message hadn't sent. And whilst I hadn't mentioned the quote below on page 68, it does mention if the email doesn't get sent, it's not effective service.
But wasn't the whole thing with the postal rule that, I suppose, once you've put your letter in the letterbox, you don't know anything about what happened to the letter? I think some judge said that the matter is out of your hands. It just doesn't seem like quite the same thing can be said of the email where you can instantly get that kind of feedback. What do you say to that?
Council recognises and appreciates this commentary. However, one must appreciate that the same could be applied to email, as your lordship mentioned earlier, where you may receive an email not sent, which could indicate you have the wrong email address or it's out of jurisdiction. Thereby, it will be similar in terms of the postal rule.
Sorry, please continue with your next submission.
I'm grateful. The second submission follows that implied terms of an advertisement could be responded by email or letter, which would constitute as an agreement. Council submits that the previous judgment where the court binds itself to Granger and Go, as well as Partridge and Crittenden, shows an error in the law in the application to imply a response by offer or email suffice. Granger and Go fails to recognise that specific terms in advertisement constitute as an offer and implies that it can be responded to by email and letter or letter. My lordship may turn to page 89 of the bundle.
Yes.
This is where Granger and Go is disputed. Persons likely to give orders and contended that as soon as an order was given to them by person receiving one of the lists, a contract to supply the specified quantity at a price named in the list was complete. This is a quote by the Solicitor Learned General that opposes the judgment, and counsel submits this as sound reasoning. This is because the term used by the respondent, which is quote unquote notify us in 24 hours in advance, implies the appellant to respond by email as an ordinary way of contacting the respondent, as no other term specified. A better alternative for the court to consider instead of binding itself to Granger and Son is Carlisle and Carbolic Walker, which implies a response via email or letter is sufficient. My lord, may turn to page 108 of the bundle.
Yes, on that.
Read the advertisement how you will, and twist it about how you will. This is a distinct promise expressed in language which is perfectly unmistakable. This first quote will imply that whatever is written in the advertisement should be adhered to. We must first consider whether this was intended to be a promise at all, or whether it was a mere puff, which meant nothing. Was it a mere puff? My answer to that question is no. And I will base my answer, and then it continues to address the advertisements. The court can see in the highlights where the case considers specific performance is required, which would be requested through the advertisement to contact them. The appellant can only assume this means email or letter will be sufficient and had to sue email as a sufficient method, as it wasn't applied otherwise. If your lordship has no further questions, this will conclude counsel's submissions.
I think, yes, you're potentially a time, so let's continue
Yeah.
there. Thank you.
My lord, I am Laura Stewart Harris and I am junior counsel on behalf of the respondent, Mr. Tariq Ali. I will address you on ground 2, urging dismissal of this appeal on the basis that emails should not be governed by the postal rule. Therefore, there had been no valid acceptance before my client had posted the second notice in the newspaper. If it pleases the court, I will briefly outline the postal rule and acceptance in contract law before submitting 3 authorities to explain why the postal rule should not govern acceptance in this instance. It is well established in contract law that acceptance should be communicated to the offeror, and contract formation occurs when acceptance is received by the offeror. This rule was created out of common sense so that offerers would not be bound by acceptances of which they were not aware. The postal rule is an exception to this general rule, where acceptance occurs upon the moment the letter is sent. This was introduced in the 19th century out of necessity because communication by post was rampant of delays, and it was not efficient to require notification of acceptance. I submit that the pragmatic reasons for the postal rules creation support the argument that it is not necessary for email communications because they are near instantaneous and reliable. My lord, may I now refer you to the leading authority on instantaneous communication and acceptance on page 4 of my bundle. This is the case of Torres and Miles Far East Corporation. Would you benefit from a brief summary of the facts?
Yes, go on.
This case related to a contract formed between parties in 2 countries, England and the Netherlands. The question to be decided was in which country the contract was formed, and so on whose law it should be ruled by. The key question in the case was in which country did acceptance occur. The court held that because the contract was formed using telex, an instantaneous mode of communication, it should be governed by the receipt rule, and therefore acceptance should be communicated, and the contract was formed in the country in which acceptance was received.
Yes.
This judgment distinguishes instantaneous communication, like telex, from postal communication, and held that for instantaneous communications, the offeree must ensure that acceptance is received by the offeror. On page 6, highlighted by the red text, Lord Justice Denning considers different scenarios of contract formation using instantaneous and near instantaneous modes of communication. He contends that for practical reasons, the offeror must be notified of acceptance, and the offeree is burdened with ensuring that it has been received, otherwise no contract will be formed. This principle promotes certainty for businesses and is necessary to ensure that both parties are at idem. I submit the emails in near instantaneous communications, just like telex, which are not characterized by the delays or multiple stages which led to the need for the postal rule. The use of emails in this instance mean that the receipt rule should apply, and no contract was formed between my client and Mr. Christoph because the offer was withdrawn before acceptance was communicated. May I now refer you to page 11 of my submissions to my second authority, the case of Brinkybon and Starhag Stahl.
Yes.
If your lordship could turn to page 14 of the bundle, the yellow highlight, which follows on to the top of page 15, shows Lord Wilberforce affirming the decision in Torres, the case that I have just taken you through, that in instances using near instantaneous communication methods, acceptance is effective when communicated to the offeror. As depicted in the yellow highlight below on page 15, Lord Wilberforce goes on to acknowledge that this will not be a universal rule, and cases will have to be resolved on their facts with reference to the intention of contracting parties, what would make business sense, and in some cases, a judgment of where the risk should lie. Lord Wilberforce highlights that there are various reasons why in that case, telex communication of acceptance may not reach the offeror immediately. For example, the telex machine could be managed by someone other than the offeror. I submit that emails should be governed by the same rules as telexes because they are very similar in nature. Delivery is near instant, but similarly, receipt by the party of the contract is neither guaranteed nor guaranteed immediately.
So forgive me, how does a telex actually?
So a telex, there are two machines. A company will have a telex machine and they'll be in one place, and then another company will also have a telex machine. A clerk, for example, will type a message in one location and this message will appear instantly on the machine in the other destination. So that's why it's not instantaneous like a conversation between parties in the same room, but it is near instantaneous. Receipt isn't guaranteed immediately. However, authorities state that similarities are sufficient that it should be ruled in the normal way by the receipt rule. Reflecting the considerations of Lord Wilberforce's judgment, I submit that Mr. Ali did not intend to be bound by email responses he had not read. It would not be fair nor practical to bind Mr. Ali to acceptances he had not seen, particularly in a period with unusually large numbers of order requests. In times of high demand, applying the postal rule to email communications could bind the offeror to acceptances they are simply unable to fulfill due to limits in stock or necessity to change delivery slots. This would lead to chaos for businesses and undermine their efficiency. I submit that the receipt rule should apply to ensure mutual agreement between the parties before they are bound, as this is crucial for business survival.
Wasn't it sort of implicit? I mean, I take your point that he was very busy and there were a lot of orders. So he was in some respects entitled to make that reduction. But wasn't it perhaps implicit in his advertisement that kind of there was a first come, first served basis to the notification? I mean, that was kind of the point of him saying you must notify us 24 hours in advance. So is it not a bit unfair on Mr. Christoph that suppose he got in ahead of anyone else? You can't claim his 1,000 kilograms of meat.
I think that although it may be unfortunate for Mr. Christoph, the law of contract has introduced the receipt rule for business practicality. And as authorities show, communications by emails, as I will go on to say, should be governed and are governed by the receipt rule. And it doesn't make sense for somebody supplying products to the public to be bound by every request, because that is unfortunately not realistic and it would not make business sense for that to be.
Well, I'm not saying he needs to be bound by everything. I'm just saying that he be bound by this request which came in
Sooner than the alteration.
than others.
I accept that, but again, how can a business person be bound by an order that they have not seen? And because, as I would go on to say, emails should be checked at the first reasonable instance. And I submit that my client did check at the first reasonable instance. He runs a business. He doesn't sit at his computer all day, and that is the unfortunate matter. He had not seen the email before the offer had been altered, and it is unfortunate. It's an unfortunate circumstance. However, he was not bound because there was no valid acceptance before the terms had been changed.
Yeah.
I have already alluded to this case, but I will take you to my final submission, the case of Thomas and BPE solicitors, which firmly ruled that emails should be governed by the receipt rule, meaning that acceptance has to be communicated to the offeror, and that this must be, the email must be read at the earliest opportunity for the business person, and I submit that this was done. Well, overall, I submit that the postal rule should not apply to email communications because it is unnecessary for near instantaneous communications. Therefore, acceptance must be received and understood by the offeror to be valid. This is for the business reasons that I have outlined. I submit, therefore, there was no valid acceptance by Mr. Christoph and no contract had been formed, and therefore my client should not have to pay damages. For these reasons, I respectfully urge you to dismiss the appeal.
Thank you. Great, well, everyone can relax. Let me just gather my thoughts for 1 second. I think that, well, I don't know, I'm interested to ask the Mooters, who do you think would win the case?
Based on the argument?
Yeah, so not based on the arguments, but who do you think had the stronger case?
Not personally, I mean,
Yeah.
Yeah, I mean, I think that's probably, in fact, not even probably, I think it's definitely true. I think the appellants, through no fault of their own, didn't really have much to go with, or much for them to stand on, just because I suppose it all comes down to that commercial sense, which was the kind of theme running through all of this. That if you place an ad in the newspaper and you really be bound by it, potentially an unlimited number of people stop. And I tried to push you on that with a sort of variation of that. And I think also the idea of the postal line to emails seems pretty absurd. Yes, the differences with it's already on quite a scant footing as far as letters are concerned. I think the Supreme Court recently said it was sort of okay with it. But when it comes to emails, particularly when you have such strong authority from the House of Lords saying we don't think this should apply to telex, let alone emails, I think it was very tough. So I thought everyone did really well, but I think hats off to the appellants for giving it a good go on I think was quite a weak case. Good. What I'll do is try and give you each a little bit of individual feedback. I have to say that the standard was really high. And I know that one of you stepped in to the breach at the very last minute, which honestly was phenomenally impressive. So I commend you for that. Okay, starting with our senior appellants. Yeah, I'm going to say this to everyone, but very strong. Great pace and tone. You were very calming presence. I think potentially, if I were trying to pick quality here, I might say you could probably be a little bit louder, actually. Not necessarily any less calm, but I think just maybe projecting a little bit more towards that. But really, overall, the tone and the register was excellent. And you extended that calmness into your responses to my interventions, and particularly the first up, that was very impressive that you weren't faced by that. You also made a good reference to the authorities. Again, if I'm nitpicking, it can be a personal preference saying judges. I thought that the passages that you were looking to draw my attention to were quite large, where possible. And I know that I'm sure that you thought about it and thought, well, actually, all of this is useful. If you can, if it's to try and reduce it, so I draw my attention to a single sentence that sums up the issue. As a judge, particularly in this context, I didn't feel entirely comfortable reading for 30 seconds in front of a room of silent people, I suppose, I might say. But overall, the use of authorities was excellent. And your timing as well was impeccably finished. I think, I wasn't fully aware of it, but I think you finished in good time and made, I think, a slight adjustment to make sure that you did. So that was good, if I've read that correctly. Moving on to senior respondents. Yes, amazing given the lack of time that we had to prepare. And again, the tone was great, the pace was great, good eye contact, which all of you did well. I think that your formalities were generally good. Occasionally, relapsed into an I feel. And that is so easy when you get a judicial intervention. I do it myself. So it's, I suppose, it's a particular problem if your tone and control are so good in the first place that the moment you're on slightly uneven footing, the formalities go. So just try to be aware of that. I suppose I forget now which the authority was that I challenged you on.
RBE of facing.
That's right.
Yeah.
I mean, it's kind of, it was a bit mean because I know that you don't really call things pens nowadays, but it was ultimately a case about land. So obviously know your authorities. But actually your answers were generally pretty good. And yeah, as well, a good time, you finished a good time. So, all right. Moving on to junior talent. I thought that, yeah, I think this was probably the position in the Moot that I would least want to have taken. So, well done. Great formalities. You potentially could benefit from going slightly slower, I thought. But your tone was excellent, eye contact and register. Maybe with the exception of one moment where I had to suppress a laugh slightly when you said thank you for your commentary, which was probably slightly sassy. But I got the gist of what you were trying to achieve. You could have said much worse. And generally, yes, you were very polite. Good use of authorities again. Did you run out of time? I was like,
Yes, I did.
okay, so yeah, that's I do with mine, but it's just something that the judge might think you're that. Yeah, being able to deal with that point, arguing that the postal law should apply to emails is just being able to get up and say anything about it, I think is very so you can it's a process. And conversely, junior respondent, I was sat here kind of thinking desperately of something to say because you probably could have said anything and I would have agreed with it. And yeah, I mean, I thought I maybe could pick you up on the telex point, but you know, you've done your research, so credit to you for that. You almost had maybe the opposite issue of your colleague of you were so well prepared in that answer that was what made you snap out of the formalities a bit. So it was at that moment that you became a little bit more relaxed because you kind of knew you were talking about something factual rather than legal. So I suppose it's just the same feedback and try and make sure when you're giving that answer that you stay nice before them. But generally the tone was good. Eye contact excellent. I have here I'm trying to pick out a nitpicking. I apologise for that, just because I was with you on the submissions, but perhaps your responses were a little bit wordy and went on for a bit too long. I mean, I think the answers that you were giving, you were absolutely fine. In general, I think when a judge asks you a question, there's probably two kinds of responses you can give. Sometimes the judge is just asking you a question which actually they kind of agree with you anyway, and they're just double checking. And you can probably give an answer in just a simple sentence. Occasionally, if the judge is really sticking the knife in and he's pointing something out to you that you really think's got you, he or she, then you may need to give a bit. But if, particularly in a Moot, you wouldn't really want it to. I would aim for not more than 3 or 4 sentences, really. But overall, this was a very strong performance, and something I should have said for all of you. Perhaps I was harsh on you because I slightly lost the train of what you're saying in sign posting. But do try and just be really clear about any points you're going to make in advance. And so what I was going to say to you was I think the sign posting was good on that point. It's just so helpful to be able to follow what we're saying in advance. And it helps me to know whether I need to ask you some questions or not fill in time. But generally, that wasn't the problem. So I hope you feel that I've been fairly even-handed with you. But really, I do, yeah, applaud because you all did exceptionally well. So perhaps we can have a round of applause. I think that's everyone needs to say.
I mean, just, thank you for the participants, the Mooters themselves. Really, thank you. Thank you, the judge, Judge James. I just hope everyone here, like, had a good idea of how a Moot is supposed to be run. We do encourage you to participate in any Moot. It's a good experience. You feel good after, once you finish. Yeah, just hope everyone just got something from this. It's really helpful.